Welcome to all. As a part of the course on insolvency and bankruptcy laws in India, before discussing the concept of nature, scope and contents of resolution plan, let us recap what we have discussed in the previous session. In the previous session, we have discussed about once the resolution professional is appointed, he is expected to appoint the valuers. Minimum 2 valuers must be appointed. Then the valuers is expected to determine fair value and liquidation value. What is the meaning of fair value? We have discussed in the previous session. We have discussed about the liquidation value, the meaning of liquidation value in the previous session. Then we have discussed that physical verification is mandatory. So that means whenever the valuer is valuing or whenever the valuer who is appointed by the resolution professional, when he is doing the valuation, when he is inspecting the inventory, physical verification is mandatory. So that means if he is sending any assistance to do the physical verification, such verification is not valid. So that means the valuer is expected to do the physical verification personally. So we have discussed this concept with the help of judgments. Then each and every class must be valued separately. So whenever the valuer is evaluating or valuing the assets, each and every class must be valued separately. And please remember, while they are doing these activities, they are expected to maintain the confidentiality. Today we are going to discuss nature, scope and contents of resolution plan. So today and tomorrow and next lesson, these 3 lessons, we are going to discuss nature, scope and contents of resolution plan in detail. So what is resolution plan? Let us discuss about the nature and scope of the resolution plan. Section 5, subsection 26 of IBC defines the term resolution plan. Resolution plan means a plan proposed by the resolution applicant for insolvency resolution of the corporate debtor as a going concern in accordance with part 2. So what is the meaning of resolution plan? Resolution plan means a plan that is proposed by the resolution applicant for the insolvency resolution of the corporate debtor. So any plan that is proposed by the resolution applicant for the insolvency resolution process, that is very, very important, going concern in accordance with part 2 of the legislation, that is called as resolution plan. Then explanation is there under this section. For the removal of doubts, it is hereby clarified that a resolution plan may include provisions for the restructuring of corporate debtor, including by way of merger, amalgamation and demerger. So if you observe the definition of resolution plan, the resolution plan can include restructuring also. So when I am talking about the restructuring includes mergers, acquisition, demerger, slum sale, everything is included within the meaning of restructuring. So that's why the concept of resolution plan is very broader in nature. So we are going to discuss in detail about this concept in the subsequent slides. Then in the case of EBIC Singapore Private Limited versus COC of Edu Company Solutions Limited. So in this case, the Supreme Court held that the resolution plan is a court sanction scheme, so which is in rem and is binding on all the stakeholders of the CD. So in this case, it was held that the resolution plan, once the resolution plan is approved by the NCLT, as already we have discussed previously, the COC is going to approve and they are going to place it before the NCLT. Then NCLT is going to approve the scheme. Okay, so once it is sanctioned, which is in rem, so that means the sanction is binding on everyone, whoever is dealing with the company. So it is binding on everyone. Okay, so it is binding on all the stakeholders of the company. So here when I am using the word stakeholders includes shareholders, corporate debtors and financial creditor, operational creditor, board of directors and everyone whoever is related to the company. So the scheme will be binding on everyone whoever is related to the company. Then how it is different from section 230. So if you observe the definition of resolution plan and the explanation given to the definition, resolution plan may include restructuring of corporate debtor, including by way of merger, amalgamation and demerger. So this merger, amalgamation, demerger, they are all discussed or they are all there under section 230 of the Companies Act. So under section 230 of the Companies Act, we are having the concept of arrangement. Though they have not specifically used the word merger, amalgamation, but they have used the word arrangement. Then how the concept of arrangement under section 230 of the Companies Act and the resolution plan under the IBC both are different. Let us try to understand. So if you observe section 230, which does not give clean state. So what is the meaning of clean state? Clean state means, suppose take the example, before CRP process, the company has done some activities. Company may be liable to pay some amount, or company is liable to pay some compensation, penalty, etc. etc. Once the CRP process is completed, once the resolution plan is approved, please remember the company will never be having any liability subsequent to the approval of resolution plan. So they are supposed to implement only resolution plan. So that means the resolution plan has to take care of all these liabilities. Okay. So once the resolution plan is approved, okay, so it is like a clean slate. Everything is cleaned. Okay. So the company will not be liable subsequently. But in case of restructuring or in case of merger, amalgamation, etc., etc., under the Companies Act 2030, the concept of clean state is not applicable. So that is the basic difference between section 230 and the resolution plan under the IBC. Okay. And that's why the options under the section 230 are limited in nature. So why? Because it only includes mergers, amalgamation, demerger, whereas the resolution plan can be anything. So it can be capital restructuring. Okay, sometimes it can include reduction of share capital. Sometimes it can include private placement. So like that, various permutations and combinations are possible in resolution plan. So that is the basic difference between resolution plan under the IBC and section 230, the arrangement under section 230 of the Companies Act. Then let us discuss about contents of resolution plan. So today we are going to discuss in detail about the contents of resolution plan. What should be there in the resolution plan? Regulation 37 of CRP regulations deals with the contents of resolution plan, which provides that. Let us discuss in detail. So regulation 37A. So in this lesson today we are going to discuss each and every clause separately. So regulation 37A, which states that transfer of all or part of the assets of the corporate debtor to one or more persons. So the resolution plan can include transfer of all or part of the assets of the corporate debtor to one or more persons. So they can transfer some part of the asset, all the assets. Okay, so transfer can be included. So in the case of stressed assets stabilization fund versus Jain Studios Limited. So in this case, NCLT principal bench held that. So what is included? What should be there in the resolution plan? It is a transfer of asset of the CD only. So when they are using the word transfer of assets of the corporate debtor, they have used the word of the corporate debtor. So it means that when corporate debtor is having ownership, then only you can transfer. If the corporate debtor is not having the ownership, merely having the possession will not be sufficient. Sometimes it is possible due to some arrangements or maybe based on some agreement, the corporate debtor may have possession over the property. So such property cannot be a part of the resolution plan. Okay. So in this case, there is stressed asset stabilization fund versus Jain Studios Limited. NCLT held that it is the transfer of asset of the CD only. So where an asset is not owned by the CD, transferring such asset is not permissible under the resolution plan. So whenever if you want to transfer, the asset must belongs to the CD only. So ownership must be required. That is, title over the property must be there with the CD. Then in another case, Embassy Property Development Private Limited versus State of Karnataka. The Supreme Court held that any property in the possession of CD under contractual arrangement, as already we have discussed, suppose based on some contract, if CD is having possession over the property, please remember merely having the possession will not be sufficient. So the CD must have the ownership. Unless you are having the ownership, such property cannot be transferred. So any property in possession of CD under contractual agreement to be excluded from the resolution plan. So merely having possession, such property must be excluded from the resolution plan. You cannot include such property. Then in another case, Nitin Chandrakant Nayak versus Sanidhya Industries LLP. So in this case, NCLAT held that assets of a personal guarantor not being assets of CD. Suppose if personal guarantor gave some property as a security, or personal guarantor is having some asset. So will it be considered to be, or can you consider such asset as a part of resolution plan? No. Okay, why? Because CD cannot be dealt with and in the resolution plan. So why? Because CD is not having the ownership. So that's why such property cannot be a part of the resolution plan. Then let us discuss the next clause. Clause B. Sale of all or part of the assets, whether subject to any security interest or not. So this is very interesting. So if you observe clause A of regulation 37, okay, if you observe the previous slide, which states that transfer of all or part of the assets. When you observe clause B is speaking about only sale of all or part of the assets. So clause A is talking about transfer, clause B which is providing for sale of assets. So clause B includes sale only, not the transfer. Okay, but if you observe legally, every transaction under regulation 37 clause B would automatically fall within the scope of regulation 37A. Why? Because transfer is very broader in nature. Okay, transfer includes sale. So that's why every transaction that falls under clause B will automatically fall under clause A. So why? Because clause A is very broader in nature. Now let us see another clause. Clause BA. Restructuring of corporate debtor by way of merger, amalgamation and demerger. So here we are having some judicial precedents are there. Interpretation is also required here. So the resolution plan can have restructuring of the corporate debtor, maybe by way of merger, amalgamation, demerger. So if you observe section 5 clause 26 also, which clearly provides that, if you observe the explanation given to the section 5 subsection 26, the resolution plan may include provisions for restructuring of the CD. Okay, so it includes merger, amalgamation and demerger. So even if you observe the contents of resolution plan also, it can have restructuring of corporate debtor by way of merger, amalgamation and demerger. Then the question mark is that the process for resolution plan is different. Under IBC there is a process is there. That is what we are discussing from the beginning. In these lessons, the process is different and it has to be approved by the NCLT. The process is different. If you observe the process for merger, amalgamation, demerger, that is, if you observe the process for arrangements under the Companies Act, the procedure is totally different. Now the question mark is that whether when the resolution plan includes arrangements under the Companies Act, whether I need to follow only IBC or else IBC plus Companies Act, that is section 230 of the Companies Act, procedure under the Companies Act, whether I need to follow both or not. That is a question mark. Fact to say, it is not clear. So in the case of J. Prakash Associates Limited versus IDBA Bank Limited, in this case, the Supreme Court commented that whether the resolution applicant need to go by procedure under section 230 or not, that is not so clear. Okay. So under section 230, who can file an application? Under section 230, members, creditors, company and liquidator. So 4 categories of the people or persons can file an application under section 230 of the Companies Act. Whereas under IBC, the resolution professional, resolution applicant also can file an application under the IBC. So these people are not included. So when you are saying that a transaction is a resolution plan, resolution professional, resolution applicant will be involved. So normally the board of directors of the company will be suspended. When the resolution professional is appointed, the board of directors of the company is going to be suspended. And the board of directors, they are replaced by the resolution professional. Resolution professional will take care of the day-to-day management of the company. Now the question mark is that under section 230, actually members, creditors, company, liquidator can only file an application. Now we don't have the company. Company means always it is board of directors. The board of directors can file an application before the NCLT. But here we don't have board of directors. So in place of board of directors, we have resolution professional. Now under section 230, resolution professional is not at all mentioned. Why? Because that is not the scope of the legislation. So that's why now it is not clear whether we need to follow section 230 again, or whether if we follow IBC, that itself is more than sufficient. Why? Because if you observe some of the provisions, subsequently we are going to discuss. If you observe the provisions of IBC, IBC is having overriding effect over all other legislations. Parallelly, IBC also provides that apart from following procedures under IBC, you are expected to follow the basic procedures under the Companies Act also. So you have to interpret harmoniously between Companies Act and IBC. Let us look at few cases. In the case of Edelweiss Asset Reconstruction Company Limited versus Synergies Dore Automotive Limited. So in this case, NCLAT held that IBC has overriding effect. Once scheme is approved under IBC, the argument is that the resolution plan cannot have merger amalgamation, is not tenable. Why? Because IBC is very broader in nature, as already we have discussed, and even if you observe section 5 subsection 26 of the Act, under the definition, explanation is there. Under the explanation, it is clearly stated that resolution plan can include merger, amalgamation, etc. also. So that's why in this judgment, NCLAT held that IBC is having overriding effect. So once it is approved, okay, so you cannot have merger amalgamation under the scheme is not tenable. So that means you can always have merger amalgamation, etc. as a part of the resolution plan only, under the scheme only. Then section 66 of the Companies Act, even you have to consider the section 66 of the Companies Act. Section 66 of the Companies Act speaks about the reduction of share capital. Okay, so whether reduction of share capital can happen, yes, it can happen through resolution plan. In another case, Reliance Industries Limited versus Ajay Joshi, NCLAT, they allowed successful resolution applicant to pursue the delisting. So through the resolution plan, can I go for delisting or not? Yes, even you can go for delisting also. So you can go for merger, amalgamation, takeover, delisting. You can go for reduction of share capital. Okay, so buyback of share capital, section 68 of the Companies Act. So all these things can be done as a part of the resolution plan. So in another case, Venkateshan Shankar Narayanan versus Tech Pro Systems Limited. So in this case, NCLT principal bench held that reduction of share capital is also allowed. So as already we have discussed, section 66, even reduction of share capital is also allowed under the Companies Act. Okay, so you need not to follow the procedure under Companies Act. You can follow the procedure under the IBC. Then, when restructuring of the seed is permitted under the resolution plan, NCLT should enable as close as possible compliance with Companies Act while ensuring full compliance with the IBC. So what it means? As already we have discussed, IBC is having overriding effect. Parallelly, IBC also provides that whenever you are following the procedure, you are expected to follow procedure in addition to the IBC procedures under the Companies Act also. So that's why if you observe above judgments, maybe Edelweiss judgment, Reliance Industries or Venkateshan judgment, if you observe all these judgments, you can understand that you are expected to follow Companies Act as close as possible. Okay, and parallelly you are expected to have full compliance with the IBC. So first you have to comply with the IBC in total. Apart from this, even you are expected to follow Companies Act also. Then let us discuss other contents. Clause C, Regulation 37, Clause C. The substantial acquisition of shares of the corporate debtor or the merger or consolidation of the corporate debtor with one or more persons. So the resolution plan can have substantial acquisition of shares also. So when I am talking about the substantial acquisition of shares of the corporate debtor, obviously, if it is a listed company, it may not be applicable in all the cases. Then SEBI SAST regulations will be applicable. That is, Substantial Acquisition and Share Transfer Regulations 2011 will be applicable. So as per the SAST regulations, generally whenever if person or person acting in concert, if they are acquiring the shares of any company, triggering points are there. If it is exceeding the triggering points, they are expected to give the open offer. But if As a part of the resolution plan, if you are acquiring the shares of corporate debtor, then you need not to give the open offer, which is provided under Regulation 10(1)(da) of SAS Regulations 2011. So, exemption is there from giving open offer to the resolution plan. In the case of ATO India Limited versus Gandhmardhan Sponge Industries Private Limited, NCLT, Kolkata bench held that. So in this case, the resolution plan was approved by the NCLT and not required to give open offer under the takeover code. So in this case, it was held that it is a listed company. So in case of listed company, they have approved the resolution plan which contains the acquisition or takeover of the company. So it was approved. Then NCLT held that. So when it is followed and when it is followed under the IBC, IBC is having overriding effect, and also under the SAS regulations, that is takeover code, you are also having an exemption from giving open offer. So that's why you need not to give the open offer under the takeover code. Now clause D. Clause D speaks about cancellation or delisting of any shares of the corporate debtor if applicable. So the resolution plan can have cancellation or delisting of any shares. So when I am talking about the delisting, okay, so if it is a listed, obviously it is a listed company. So unless it is a listed company, the question of delisting will not come into the picture. Okay, so maybe you are talking about the resolution plan of the listed company. So when you are talking about the delisting, SEBI, the delisting of equity shares regulations 2021 will be applicable. So if you observe regulation 3 of SEBI delisting regulations, which clearly provides that the regulation shall not apply to any delisting of shares, that is equity shares of a listed company made in pursuance of IBC. So when you are going for delisting in pursuance of IBC, then the delisting regulations will not be applicable. Okay, so only thing is that the public shares should be provided an exit opportunity. Okay, so whenever you are going for delisting, as per the delisting regulations, you are expected to provide the exit opportunity to the existing shareholders. Okay, in the case of V. Shankar RP of Sri Ramanjaneya Ispat Private Limited versus Sri Ramanjaneya Ispat Private Limited. So in this case, NCLT Hyderabad bench approved a transaction where it involved the delisting of securities. So when you are talking about the delisting of securities, the law relating to, I'm not talking about the only delisting. Okay, if the resolution plan contains a delisting, okay, so it is not so clear. Though there are exemptions are there under SEBI SAS regulations, but to protect the interest of the public shareholders and to prevent the abuse of securities in the market, SEBI and IBBA both are expected to work together. Accordingly, they are supposed to amend the legislations accordingly. Why? Because the law relating to IBC interface with having the interconnection with the delisting. That means as a part of resolution plan, whenever you are having delisting, there is a possibility they may abuse the provisions of IBC whereby to circumvent the provisions of the delisting regulations. So that's why we should be very careful. SEBI and IBBA, they are expected to work together to protect the interest of the public shareholders. Then, Regulation 37D, Clause D. So, resolution plan may have satisfaction or modification of any security interest. In the case of Vijay Kumar Jain versus Standard Chartered Bank, the Supreme Court held that the secured creditor may be required to relinquish its security for the amount received under the resolution plan. So, there is a possibility you can relinquish the security given. Then in another case law, Anuj Jain versus Axis Bank, the Supreme Court held that the security interest in terms of section 3 subsection 31 means a right or title or interest or claim of property created in favor of the secured creditor. So whenever I am creating any right or any title or interest or claim over the property, that is called as security interest. So please remember the relevant documentation to give effect to satisfaction charge need to be registered under the law. So though you are satisfying or modifying the security interest subsequent to the satisfaction, okay, so you are supposed to follow certain other formalities, maybe under the Registration Act, maybe under the Stamps Act, maybe under the Companies Act. You are supposed to follow certain other procedures. depending on the transaction, other procedure to be followed. Okay, so this procedure to be followed, even though that is a part of the resolution plan. Then if you observe regulation 37 clause E. So clause E speaking about curing or waiving of any breach of the terms of any debt due from the corporate debtor. So they may cure or they may waive of any breach of the terms of the debt. Okay, stating that you are not liable. Then another important clause, generally majority of the cases this clause will be there in the resolution plans. Clause F, reduction in the amount payable to the creditor. Okay, so possibility is there, the resolution plan may say that imagine the creditor may be entitled to receive 100 rupees. I'm just giving the example, 100 rupees. So the resolution plan may say that we'll give 10 rupees to you or 50 rupees to you, 80 rupees to you. Okay, so this is called as haircut. Okay, so in majority of the cases this is happening actually. So in the case of JP Kensington Boulevard Apartments Welfare Association versus NBCC India Limited. So in this case, the Supreme Court held that the regulation permits a resolution plan to reduce any debts due to any creditor. So possibility is there, any debts can be reduced which is due to the creditor. But this is the most used clause in the resolution plan. As already I told you, majority of the cases this is the clause generally used. Okay, the plan can provide for haircut. This helps the financial creditor to reinvest such amount into the economy. So what is the logic behind the haircut? So why the financial creditors are willing to accept a plan where there is a haircut is there? So the logic is that, suppose take the example, imagine I am the financial creditor, maybe one of the banking institution. I gave 100 rupees loan to one company. 100 rupees is due, imagine. Out of the 100 rupees, if I don't approve the scheme, maybe I am receiving 80 rupees or 70 rupees as the case may be. So if I don't approve the scheme, I may lose this 70 rupees also. Okay, so that's why what is the bank tendency is that they'll try to accept the haircut. Then remaining 70 rupees reinvested into the economy. So as a whole, at the macro level, if you observe, this is going to help the economy. Instead of blocking the amount in one place where the business is not going on, it's better if you can withdraw the money and if you can reinvest somewhere else. Okay, so that is the logic behind accepting haircuts in case of resolution plan. So regulation 37 clause G, possibility is there, resolution plan can have extension of maturity date or a change in the interest rate or other terms of the debt due from the corporate debtor. So you can have extension of maturity date, maybe I am liable to pay today. Maybe you can say that after 1 year. Okay, maturity date I may extend. After 1 year, the corporate debtor can pay. So that you are giving some leverage to the corporate debtor. Okay, or a change in the interest rate. So instead of losing entire money, if I can reduce the interest rate, maybe I can receive the money. Okay, so change in the interest rate or other terms of the debts can be changed as a part of the resolution plan. Even that is also possible. Now, the resolution plan can have amendment of the constitutional documents. So what is this constitutional documents? Constitutional documents includes memorandum of association and articles of association. In India, company is going to be incorporated based on the memorandum of association and articles of association. So the resolution plan can include amendments to the constitutional documents also. That is amendment to the articles of association and memorandum of association. In the case of Next Orbit Ventures Fund versus Print House India Private Limited. So in this case, NCLAT held that the resolution plan can include any changes in memorandum of association or articles of association, including main objectives also. Changes in the main objectives. Okay. So generally, whenever you are altering the memorandum of association, whenever you are altering the objective clause, you are supposed to follow the procedure that is prescribed under the Companies Act. Here, you need not to follow the procedure. Okay, it's a part and parcel of the resolution plan. So, as a part of the resolution plan, you can alter any clauses in the MOA or AOA as may be required. Okay. Then next clause I, regulation 37 clause I, issuance of securities of the corporate debtor for cash, property, securities, or in exchange for claims or interest or other appropriate purpose. So possibility is that you can issue the securities of a corporate debtor. So instead of paying the amount, or instead of clearing the debts, you can issue the securities of the corporate debtor. Okay. So another clause, clause J, issuance of securities of the corporate debtor for cash, property, securities, or in exchange for claims or interest or other appropriate purpose. Then clause K, change in the technology used by the corporate debtor. So maybe resolution plan can include changes in the technology also. Then L, obtaining necessary approvals from the central government and state government or other authority. So the resolution plan may include, sometimes whenever you are approving the resolution plan, if you want to go ahead with the scheme, you may need to get the approval from the local authorities. Okay. So in one of the famous case law, JP Kensington case law, the Supreme Court held that approval from the local authority is required. Okay, though IBC Act states that it is having the overriding effect over all other legislations, but Regulation 37L clearly provides that you are supposed to, or the resolution plan can have a provision where you are supposed to get the approval from the central government and state governments or other authorities. Okay, in this case law, actually they are supposed to get the approval from the local authorities. Okay, but the company argued that because it is a part of the resolution plan, so that's why we need not to take the approval from the local authorities. But the court of law held that no, because the section or the regulation clearly provides that you are supposed to take the approval whenever there is a requirement is there, because each and every regulatory authorities, their perception is different. Okay, the purpose is different. So everything cannot be addressed to IBC. That is practically impossible. So that's why approval from the local authorities whenever there is a requirement is there, so you are supposed to get the approval apart from the IBC. Next, clause M, sale of one or more assets of corporate debtor to one or more successful resolution applicants, submitting a resolution plan for such assets and manner of dealing with remaining assets. So the plan can have sale of one or more assets, even that is also possible, okay, to the successful resolution applicant. Now, till now, we have discussed Regulation 37 in detail. Let us recap what we have discussed till now. So, in this lesson, we have discussed the nature and scope of the resolution plan. So, what is the meaning of resolution plan? Okay, what is the nature of the resolution plan? We have discussed. Then we started talking about the contents of resolution plan. So, we discussed in detail about the Regulation 37. Regulation 37 is having various clauses. Okay, so we have discussed few clauses like transfer of all or part of the assets of the corporate debtor. The resolution plan can have the provision for transfer of all the property. So we have discussed the difference between clause A and clause B. Okay, clause A is speaking about the transfer, clause B is talking about the sale. Okay, so what is the difference between transfer and sale? And we discussed that sale is a part of the transfer. So always transfer is a very broader in nature. So always clause B will be within the scope of the clause A. We have discussed those points. Then sale of all or part of the assets of the assets. Then restructuring of the corporate debtor we have discussed. Okay, whether restructuring of the corporate debtor can be a part of the resolution plan. Yes, even restructuring can be a part of the resolution plan. In such cases, the question mark is that whether you need to follow procedure under section 230 of the Companies Act. Court is of the opinion, if you observe various paucity of the time, we may not be in a position to discuss all the judgments, but if you observe various judgments given by NCLT, NCLAT, Supreme Court, will understand that though you are not expected to follow section 230 in detail, but you are expected to follow procedure under IBC, especially when in case of restructuring of the corporate debtor as a part of the resolution plan, you are expected to follow IBC in full. And IBC itself provides that you are expected to follow Companies Act procedure also. Okay. So unless there is a contrary is there between the Companies Act and IBC, first you are expected to follow IBC, then additionally you are expected to follow Companies Act also. Okay, so whenever you are interpreting these two legislations, you are expected to interpret harmoniously. Then obtaining approval from the authorities. So the resolution plan can include the provisions. You are taking over the resolution plan, you may need to get the approval from the other authorities. Okay. Then amendment of the constitutional documents, like it may include amendment of memorandum of association and articles of association also. The resolution plan can include. So these are all the various things that we have discussed in this lesson. Thank you.